There are moments when the actions of government raise questions that extend far beyond policy, questions about transparency, accountability, and the public's right to know. In Nova Scotia, the provincial government is moving to expand its publication ban on identifying children who have been part of the child protection system, extending that secrecy even after a child has died. If passed, the proposed amendments to the Child and Family Services Act would be more restrictive than similar laws in other provinces. Critics and child welfare experts warn the change could reduce accountability and limit public scrutiny of how the system operates. The timing has drawn particular attention. The legislation was introduced roughly 10 months after the disappearance of Jack and Lilly Sullivan, two young siblings who vanished from their rural Nova Scotia home. Since then, the family's past interactions with the province's child protection system have come under increasing scrutiny. Lily was 6, Jack was 4. The children have been the focus of an RCMP major crime investigation since May and have not been declared deceased. Reporting by the Globe and Mail has focused on events in the months leading up to their disappearance. According to the newspaper, a provincial child protection social worker had investigated a report of suspected abuse or neglect at the children's home in Lansdowne, Nova Scotia. The Globe also reported concerns about conditions inside the home, including allegations of drug abuse, reports that the children had been seen with multiple black eyes, and claims that their mother had been subjected to physical abuse. Last year, Scott Armstrong, the former minister responsible for opportunities and social development, told the Globe and Mail he had begun reviewing the involvement of the child protection social worker who had contact with the children prior to their disappearance. Under the proposed expansion of the publication ban, if the children were ultimately determined to be deceased, media outlets would be prohibited from reporting on details of their child protection case. The legislation would also give the minister sole discretion over whether such a ban could ever be lifted. Current Minister Barbara Adams, who introduced the amendments last week, has reportedly cited ethics and privacy laws as the reason for declining to answer questions about the Sullivan case. The proposal has also drawn sharp criticism from media organization and legal experts. At a legislative standing committee this week, the Canadian Media Lawyers Association and CBC argued the amendments represent a significant departure from long-standing norms around transparency in Canada. In written submissions, lawyer David Hutt, representing the groups, warned that changes would impose unjustified limits on freedom of the press and access to information. He argued the amendments could reduce accountability, restrict public scrutiny of provincial agencies, limit a family's ability to speak publicly about a child who has died while involved with children and family services, and potentially allow systemic problems that harm children to remain hidden. Hutt also raised concerns about the impact on Canada's open court principles. Identifying individuals accused of crimes, he noted, is a cornerstone of Canada's justice system. In his view, the proposed ban risks protecting the identities of individuals who had relationships with a deceased child, people who may ultimately be accountable for what happened. He also argued that the rationale for protecting a deceased child's identity is fundamentally different from protecting a living child. Once a child has died, he said the concerns about stigma or emotional harm no longer apply. The legislation would also require anyone seeking to identify a deceased child to obtain consent from the minister, a provision Hutt described as troubling. Requiring families to ask permission from government to publicly identify their own deceased child, he said, is demeaning, strips parents of agency, and raises serious concerns for the principles of open courts and the rule of law in a democratic society. Speaking about the case of Jack and Lilly Sullivan, where public interest has been intense, Hutt said the issue ultimately comes down to balance. We do need to find a balance between privacy and accountability, he said. But as Nova Scotia lawmakers debate expanding secrecy around the child protection system, critics argue the stakes go far beyond legislation. At the heart of the debate is whether protecting privacy should come at the cost of public transparency, particularly when children may have been in contact with the very system meant to safeguard them. The search for Jack and Lilly Sullivan continues, and as Nova Scotia debates expanding secrecy around its child protection system, one question lingers. Who is the system really protecting? The source for this video comes from the Globe and Mail, March 4th issue. If you would like to stay up to date on developments in the Jack and Lilly Sullivan case, as well as the other cases that I cover, please subscribe, follow, do what you have to do, and consider sharing this video out. This is a really, really important development, certainly for Nova Scotia. Personally, I think this needs to be fought tooth and nail with everything possible. The fact that the system is trying to protect the system is deplorable. Like, share, follow, subscribe. Please consider supporting the channel. And for those who already do support the channel regularly, I thank you from the bottom of my heart. I absolutely could not do the work and spend the time that I do without your support. Thank you so much.